Hello and welcome to Bar10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. As a result, we upload 10 MBE questions every single day at 8 a.m. Eastern Standard Time. Don't forget to like, subscribe, and click the notification bell so that you can be updated every time we upload new content. We also upload other content other than MBE questions, so please be on the lookout for that and ensure you ring that bell so you can be updated every time we upload that content. Question number 1. Sam decided to kill his boss, Anna, after she told him that he would be fired if his work did not improve. Sam knew Anna was scheduled to go on a business trip on Monday morning. On Sunday morning, Sam went to the company parking garage and put a bomb in the company car that Anna usually drove. The bomb was wired to go off when the car engine started. Sam then left town. At 5 a.m. Monday, Sam, after driving all night, was overcome with remorse and had a change of heart. He called the security officer on duty at the company and told him about the bomb. The security officer said he would take care of the matter. An hour later, the officer put a note on Anna's desk telling her of the message. He then looked at the car but could not see any signs of a bomb. He printed a sign saying, "Do not use this car," put it on the windshield, and went to call the police. Before the police arrived, Lois, a company vice president, got into the car and started the engine. The bomb went off, killing her. The jurisdiction defines murder in the first degree as any homicide committed with premeditation and deliberation, or any murder in the commission of a common law felony. Second degree murder is defined as all other murder at common law. Manslaughter is defined by the common law. Sam is guilty, based on his actions, of A, murder in the first degree, because with premeditation and deliberation, he killed whoever would start the car. B, murder in the second degree, because he had no intention of killing Lois. C, manslaughter, because at the time of the explosion he had no intent to kill, and the death of Lois was in part the fault of the security officer. Or D, only attempted murder of Anna, because the death of Lois was the result of the security officer's negligence. Take 10 seconds and choose the best option now. If you chose option A, you'd be correct. Murder in the first degree, because with premeditation and deliberation, he killed whoever would start the car. First degree murder is created by statute and typically consists of 1, an intentional killing, 2, with time to reflect upon that killing, and 3, doing so in a cool and dispassionate manner. In this case, the jurisdiction defines murder in the first degree as any homicide committed with premeditation and deliberation. Sam placed a car bomb with premeditation and deliberation in an attempt to kill Anna. While it is true that Sam had no intention to kill Lois, the theory of transferred intent would still make Sam guilty of murder in the first degree. Question number 2. On March 1st, mechanic contracted to repair Textiles' knitting machine and to complete the job by March 6th. On March 2nd, Textiles contracted to manufacture and deliver specified cloth to Knitwear on March 15th. Textiles knew that it would have to use the machine then under repair to perform this contract, because the Knitwear order was for a rush job. Knitwear and Textiles included in their contract a liquidated damages clause, providing that Textiles would pay $5,000 for each day's delay in delivery after March 15th. Mechanic was inexcusably 5 days late in repairing the machine, and as a result, Textile was 5 days late in delivering the cloth to Knitwear. Textiles paid $25,000 to Knitwear as liquidated damages and now sues Mechanic for $25,000. Both Mechanic and Textiles knew when making their contract on March 1st that under ordinary circumstances, Textiles would sustain little to no damages of any kind as a result of a 5-day delay in the machine repair. Assuming the $5,000 liquidated damages clause in the Knitwear Textiles contract is valid, which of the following arguments will serve as a mechanic's best defense to Textiles' action? A. Time was not of the essence in the Mechanic Textiles contract. B. Mechanic had no reason to foresee on March 1st that Knitwear would suffer consequential damages in the amount of $25,000. C. By entering into the Knitwear contract while knowing that its knitting machine was being repaired, Textiles assumed the risk of any delay or loss to Knitwear. Or D, In all probability, the liquidated damages paid by textiles to knitwear are not the same amount as the actual damages sustained by knitwear in consequence of textiles' late delivery of the cloth. Take 10 seconds and choose the best option now. If you chose option B, you'd be correct. Mechanic had no reason to foresee on March 1st that knitwear would suffer consequential damages in the amount of $25,000. The rule for consequential damages is that to be recoverable, these damages must have already arose naturally from the breach, and they must have reasonably been foreseeable at the time of the contract formation. In this case, Mechanic had no reason to believe that textiles would suffer $25,000 of damages as a result of this 5-day delay in the repair of the machine. Both Mechanics and Textiles knew when making their contract on March 1st that under ordinary circumstances, Textiles would sustain little or no damages of any kind as a result of a 5-day delay in the machine's repair. As such, Mechanics' best defense to Textiles' action is that Mechanic had no reason to foresee at the time of contract formation that knitwear would suffer consequential damages in the amount of $25,000, given the fact that the contract between the other two parties in knitwear and textiles had in fact not occurred as of yet. So it would not have been possible on March 1st when the initial contract between Mechanic and Textiles was created for this damage to have occurred. So it would not be foreseeable if it wasn't a possibility at the time of the incident, of the initial contract. Question number 3. The Sports Championship Revenue Enhancement Act is a federal statute that has enacted as part of a comprehensive program to eliminate the federal budget deficit. That act imposed, for a period of 5 years, a 50% excise tax on the price of tickets to championship sporting events. Such events included the World Series, the Super Bowl, major college bowl games, and similar championship sporting events. The federal tax is probably A, constitutional, because the compelling national interest in reducing the federal budget deficit justifies this tax as a temporary emergency measure. B, constitutional, because an act of Congress that appears to be a revenue-raising measure on its face is not rendered invalid because it may have adverse economic consequences for the activity taxed. C, unconstitutional, because a 50% tax is likely to reduce attendance at championship sporting events and therefore is not rationally related to the legitimate interest of Congress in eliminating the budget deficit. Or D, unconstitutional, because Congress violates the equal protection component of the Fifth Amendment by singling out championship sporting events for this tax while failing to tax other major sporting events, artistic or entertainment events to which tickets are sold. Take 10 seconds. I hope you got this one right. It's B, constitutional, because an act of Congress that appears to be a revenue-raising measure on its face is not rendered invalid because it may have adverse economic consequences for the activity taxed. Congress has the power to tax for the general welfare, and taxes will be upheld if the tax bears some reasonable relationship to revenue production or if Congress has independent authority to regulate the activity being taxed. Here, a federal statute imposed a 50% excise tax on the price of tickets to championship sporting events. This tax likely falls within Congress's power to tax for the general welfare, so it will likely be constitutional, even if it may have an adverse economic consequence for the activity tax. Thus, this federal tax is probably constitutional, because an act of Congress that appears to be a revenue-raising measure on its face is not rendered invalid because it may have adverse economic consequences for the activity taxed. Now, let's take a look at the other options here so we can go through the thought process of elimination. Let's look at A, constitutional, because the compelling national interest in reducing the federal budget deficit justifies this tax as a temporary emergency measure. Immediately, we're faced with the fact that this answer says temporary emergency measure. The fact pattern says nothing of this being a temporary measure. In fact, it specifies that it was for a 5-year period of time. That being said, there's no definition as to whether that's temporary, that's emergent, or not. So as a result, A is not possibly correct because it just simply doesn't fit the facts properly. Now, C and D are in a world unto themselves. C, unconstitutional because a 50% tax is likely to reduce attendance at championship sporting events and therefore is not rationally related to the legitimate interests of Congress in eliminating the budget deficit. If you look at the two components of that answer, one, initially it says because a 50% tax is likely to reduce attendance at championship sporting events. Okay, let's look at that on its face. Is that necessarily a problem? While it wouldn't be fantastic for the teams and for the events, legally, the fact that the effect of the legislation or a statute would be that there'd be lessened attendance or reduced attendance wouldn't necessarily be problematic or wouldn't necessarily negate that statute. Finally, the second portion of the answer says, therefore, it is not rationally related to the legitimate interests of Congress in eliminating the budget deficit. Again, it's a bit conclusory. Just because attendance goes down doesn't mean that this something isn't rationally related to governmental interests. Secondarily, if you think this through, the only income that the federal government would be receiving is the tax funds because the ticket fees are not payable to the federal government. So as a result, anything, even if there is a reduction in attendance, the only thing that the federal government cares for with regards to its tax is the 50% tax in whoever actually in fact does attend. Because prior to the legislation, prior to the statute, they're receiving zero tax dollars on whatever attendance is actually in fact coming into the stadium. Subsequent to the statute, they're receiving 50% tax on whoever actually in fact does. So 0 and 50% of 0 is definitely not better than 50% of something. So I'm not certain that C is in and of itself making much sense. D, finally. Unconstitutional because Congress violates the equal protection component of the Fifth Amendment by singling out championship sporting events. Now, interestingly enough, this seems to show that sporting events or different types of sporting events are on par with some of the distinctions which the law has previously made, such as gender, sexual orientation, etc., which are points which an individual cannot be discriminated against. However, there is nothing which states that different types of sporting events cannot be discriminated against over others. I don't think that C or D make much sense and are not the basis for any possible real answer in the real world. So as a result, we're left with just B as the possible answer. Question number 4. In a prosecution of Drew for forgery, the defense objects to the testimony of West, a government expert, on the ground of inadequate qualifications. The government seeks to introduce a letter from the expert's former criminology professor, stating that West is generally acknowledged in his field as well as qualified. On the issue of the expert's qualification, the letter may be considered by A, the jury without regard to the hearsay rule, B, the judge without regard to the hearsay rule, C, neither the judge nor the jury because it is hearsay not within any exception, or D, both the judge and the jury because the letter is not offered for a hearsay purpose. Take 10 seconds. If you chose option B, the judge, without regard to the hearsay rule, you'd be correct. Generally, the judge has the opportunity to review the qualifications for an expert witness before making a determination. And as a result, anything, even hearsay, can be, as a result, reviewed by the judge. Question number 5. Penstock owned a large tract of land on the shore of a lake. Drury lived on a stream that ran along one boundary of Penstock's land and into the lake. At some time in the past, a channel had been cut across Penstock's land from the stream to the lake at a point some distance from the mouth of the stream. From where Drury lived, the channel served as a convenient shortcut to the lake. Erroneously believing that the channel was a public waterway, Drury made frequent trips through the channel in his motorboat. His use of the channel caused no harm to the land through which it passed. If Penstock asserts a claim for damages against Drury based on trespass, Which of the following would be the correct disposition of the case? A. Judgment for Penstock for nominal damages because Drury intentionally used the channel. B. Judgment for Drury if he did not use the channel after learning of Penstock's ownership claim. C. Judgment for Drury because he caused no harm to Penstock's land. Or D. Judgment for Drury because when he used the channel, he believed it was a public waterway. Take 10 seconds and choose the best option now. If you chose option A, you'd be correct. Judgment for Penstock for nominal damages because Drury intentionally used the channel. Trespass to land is the wrongful physical invasion of plaintiff's property and can occur when the defendant intentionally enters plaintiff's land without permission. It is not required that the defendant intends the entry be wrongful. Rather, the defendant only needs to intend actual entry onto the piece of land. Here, Drury intentionally entered the channel that runs across Penstock's land to use it as a shortcut to the lake. When Drury did not intend to trespass, Drury's intentional use of the channel is still sufficient to meet the intent element of trespass to land. Accordingly, if Penstock asserts a claim for damages against Drury based on the trespass, judgment will be for Penstock for nominal damages because Drury intentionally used the channel. And the basis for it being nominal damages is, of course, the fact that the fact pattern explains to you that there were, in fact, no actual damages. So the nominal damages would be simply for the purposes of dictating a winner. Question number 6. Dart is charged with the statutory offense of knowingly violating a regulation of the State Alcoholic Beverage Control Board, and specifically that he knowingly violated regulation number 345-90, issued by the State Alcoholic Beverage Control Board. That regulation prohibits the sale of alcoholic beverages to any person under the age of 18 and also prohibits the sale of any alcoholic beverage to a person over the age of 17 and under the age of 22, without the presentation of such person's driver's license or other identification showing the age of the purchaser to be 18 or older. The evidence showed that Dart was a bartender in a tavern and sold a bottle of beer to a person who was 17 years old, and that Dart did not ask for or see the purchaser's driver's license or any other identification. Which of the following, if found by the jury, would be of the most help to Dart? A. The purchaser had a driver's license that falsely showed his age to be 21. B. Dart had never been told he was supposed to check identification of persons over 17 and under 22 before selling them alcohol. C. Dart did not know that the regulations classified beer as an alcoholic beverage. Or D. Dart mistakenly believed the purchaser to be 24 years old. Take 10 seconds and choose the best answer now. If you chose option D, you'd be correct. Dart mistakenly believed the purchaser to be 24 years old. The regulation prohibits the sale of alcoholic beverages to any person under the age of 18 and also prohibits the sale of any alcoholic beverage to a person over the age of 17 but under the age of 22 without the presentation of such person's driver's license or other identification showing the age of the purchaser to be 18 or older. Dart has been charged with knowingly violating this regulation. As such, Dart's best defense is that he was unaware that the regulation applied to the transaction in question because this would negate the required mens rea. This is why D is the best answer. If Dart mistakenly believed that the purchaser was 24 years old, he would not be prevented from selling the bottles of beer to the purchaser, nor would he be required to ask for ID before selling the bottle of beer to the purchaser. Answer choice A, on the other hand, does not help Dart, because even if the purchaser had possession of a fake ID that showed his age to be 21, Dart never asked to see this identification, so he would still have violated the regulation. And now we're looking at B and C, which tests Dart's knowledge. Dart's knowledge, again, with regards to any statute, generally ignorance of the law is no defense. B and C are ignorance of the law defenses. As a result, A, B, and C are not correct, and D is the only possible correct answer. Question number 7. Structo contracted with Bailey to construct for $500,000 a warehouse and an access driveway at highway level. Shortly after commencing work on the driveway, which required for the specified level some excavation and removal of surface material, Structo unexpectedly encountered a large mass of solid rock. For this question only, assume the following facts. Structo informed Bailey accurately that because of the rock, the driveway as specified would cost at least $20,000 more than figured, and demanded that reason a total contract price of $520,000 instead would be appropriate. Since Bailey was expecting warehousing customers immediately after the agreed completion date, he signed a writing promising to pay the additional $20,000. Following timely completion of the warehouse and driveway, which conformed to the contract in all respects, Bailey refused to pay Structo more than $500,000. What is the maximum amount to which Structo is entitled? A. $500,000 because there was no consideration for Bailey's promise to pay the additional $20,000. B. $500,000 because Bailey's promise to pay the additional $20,000 was exacted under duress. C. $520,000 because the modification was fair and was made in light of circumstances not anticipated by the parties when the original contract was made. Or D. $520,000 provided that the reasonable value of Structo's total performance was that much or more. Take 10 seconds and choose the best answer now. If you chose option C, you'd be correct. $520,000 because the modification was fair and was made in light of the circumstances not anticipated by the parties when the original contract was made. The rule is that a contract may be excused by contract modification. Modification is an agreement by parties to an existing contract to accept a different agreement in satisfaction of the existing obligation. In this case, after contracting with Bailey to construct a warehouse and an access driveway at highway level for $500,000, Structo unexpectedly encountered a large mass of solid rock. For this reason, he demanded that the contract price be increased by $20,000 to $520,000, and Bailey agreed in a signed writing. This is a valid contract modification that was fair and made in light of circumstances not anticipated by the parties when the original contract was made, so Structo will be entitled to the full $520,000. Question number 8. In a federal court diversity action by Plant against Decord on an insurance claim, a question arose whether the court should apply a presumption that, where both husband and wife were killed in a common accident, the husband died last. Whether this presumption should be applied is to be determined according to A. Traditional common law, B. Federal statutory law, C. The law of the state whose substantive law is applied, or D. The federal common law. Take 10 seconds and choose the best answer now. If you chose C, the law of the state whose substantive law is applied, you'd be correct. The law is that generally the rule of law applied in federal court diversity actions is the law of the state where the action was filed. Here, the federal court in a diversity action is faced with an issue of whether to apply a legal presumption. The federal court should make its decision on this issue based on the substantive law of the state where the action was filed. Thus, whether this presumption should be applied is to be determined according to the law of the state whose substantive law is applied. Question number 9. Abel conveyed Blackacre to Baker by a warranty deed. Baker recorded the deed 4 days later. After the conveyance, but prior to Baker's recording of the deed, Smollett properly filed a judgment against Abel. The two pertinent statutes in the jurisdiction provide the following. A. Any judgment properly filed shall for 10 years from filing be a lien on the real property then owned or subsequently acquired by any person against whom the judgment is rendered. And 2. No conveyance or mortgage of real property shall be good against subsequent purchasers for value and without notice unless the same be recorded according to law. The Recording Act has no provision for a grace period. Smollett joined both Abel and Baker in an appropriate action to foreclose a judgment lien against Blackacre. If Smollett is unsuccessful, it will be because A. Abel's warranty to title to Baker defeats Smollett's claim. B. Smollett is not a purchaser for value. C. Any deed is superior to a judgment lien. Or D. 4 days is not an unreasonable delay in recording a deed. Take 10 seconds and choose the best answer now. If you chose option B, Smollett is not a purchaser for value, you'd be correct. The recording system protects bona fide purchasers and mortgagees only. A recording statute and a notice jurisdiction protects a bona fide purchaser regardless of who records first. Here, Smollett filed a judgment against Abel after Abel had conveyed Blackacre to Baker. This judgment cannot act as a lien on Blackacre under the first statute because Abel no longer owns Blackacre after conveying to Baker. The second statute outlines a notice recording system to protect a bona fide purchaser. If Smollett qualifies as a BFP or a bona fide purchaser, then Smollett's interest in Blackacre, which was obtained subsequent to Baker's interest in Blackacre, will take priority because Smollett did not have any notice of Baker's interest in Blackacre because the judgment was filed prior to Baker recording the deed. The only question remaining is if Smollett can be considered a purchaser for value. As a judgment lien creditor, therefore, if Smollett is unsuccessful, it will be because Smollett is not a purchaser for value. And our final question in this grouping, question number 10. David built in his backyard a garage that encroached 2 feet across the property line onto property owned by his neighbor, Prudence. Thereafter, David sold his property to Drake. Prudence was unaware, prior to David's sale to Drake, of the encroachment of the garage onto her property. When she thereafter learned of the encroachment, she sued David for damages for trespass. In this action, will Prudence prevail? A. No, unless David was aware of the encroachment when the garage was built. B. No, because David no longer owns or possesses the garage. C. Yes, because David knew where the garage was located, whether or not he knew where the property line was. Or D. Yes, unless Drake was aware of the encroachment when he purchased the property. Take 10 seconds and choose the best option now. The correct answer would be C, yes, because David knew where the garage was located, whether or not he knew where the property line was. Trespass to land is the physical invasion of plaintiff's real property and occurs either when the defendant intentionally enters plaintiff's land without permission, the defendant remains on the land without the right to be there, even if the original entry was rightful, or the defendant places a tangible object on or refuses to remove from plaintiff's land or without permission. For trespass, the defendant only needs to intend actual entry onto the piece of land. The wrongful quality of the entry must be present in fact, but it is not required that the defendant intend the entry to be wrongful. In this case, David built a garage in his backyard that encroached 2 feet across the property line onto property owned by his neighbor, Prudence. Clearly, David intended actual entry on Prudence's land, and as such, Prudence will prevail in an action for trespass against David because David knew where the garage was located. Remember, there's no requirement that David intend the entry to be wrongful. All that matters is that the entry is in fact wrongful and that David intended the actual entry onto the land. As a result, option C would be the best answer. As always, thank you for joining us here on Bar10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. We upload content every day at 8 a.m. Eastern Standard Time. Please don't forget to like, subscribe, and ring the notification bell so that you can be updated every time we upload new content.